Okay. Well, thank you. Again, looking at page 166 of your packet, the statistics are for last fiscal year, June 1st, 2023 through April 30th of 2024. In California, the licensed population has increased fairly moderately by 1,081 licensees. We're actively trying to assist applicants, qualified applicants, obtain a license. One way we do that is through our applicant workshops. We have those monthly in English and Spanish, and I want to thank Nevada for leading the way on that, because that's something I learned from Nevada. They were having monthly workshops, and it's helping here in California. I think it's an opportunity, though, to reach out to other communities to increase the California licensed population. If you look at the application fee and the sole owner renewal fee, we were able to modestly raise those fees approximately 2 years ago. And at that time, we were on the verge of not being solvent. So in raising the fees, we're very pleased that now we have a 5-month reserve of approximately $37 million. So you can see that in doing that, though, we kept the sole owner renewal fee at $450. The corporation, limited liability companies, their renewal fee was raised to $700. And again, that's a 2-year renewal fee. Yesterday, the California board looked at the handyman or handy person exemption. It's currently $500. The board did vote to support a bill that would raise it to $1,000 with specific restrictions. And those restrictions are to protect consumers, protect the public, to protect the worker, not make sure that the work that's being performed doesn't require a permit, as an example, or require the hiring of workers. So workers would not be able to be hired under the California Handyman Exemption without pending legislation. California has reciprocity agreements with 3 states. In the last year, 49 licenses were issued. I understand that some of the Nevada board members and California board members have benefited from the exam waiver or licensure by endorsement that Nevada has. And if there are any Nevada board members here today that are licensed, I would encourage you to obtain a California license. So we can talk about that after the meeting.
And likewise.
Okay. So we also are seeing an increase in solar complaints. You'll see that during this reporting period, we received 16,173 complaints. Over 2,000 were against solar contractors. There are currently over 900 solar complaints open in California. Just really looking to work with the solar industry. I know we have a representative with us here today to look for opportunities for solar contractors to not receive the complaint to begin with, and if they do, to identify some efficiencies in resolving that. And I think that'll be a topic that'll be discussed later this morning. California does not have a recovery fund. We did have a solar recovery fund. It was a one-time appropriation. It has been expended. It was helpful. And as Margie Green pointed out, what we found is that some contractors created a lot of harm, potentially, up to $1 million of financial harm that really hit our recovery fund hard. In California, we focus very hard on trying to negotiate settlements. We have an arbitration program. We have orders of correction in our administrative legal actions. And those programs resulted in $31 million in recovery to consumers. So we're proud of that. Something the board may think about in the future in California is whether to have a recovery fund similar to Nevada, but at this point we do not have one, and we're not currently proposing or putting a proposal together for a recovery fund. So that would be a statistical update for California. Any questions? Any board comments?
Any questions from board members? Comments?
Thank you for that discussion from both California and Nevada. And just as a final call, are there any board members or any members of the public that have any questions or comments?
I just had a quick question on all the states that have like reciprocity agreements to have a licensing in Nevada. are fees collected on each of those contractors that apply for that exemption or for the, to be licensed?
In Nevada, yes.
Same in California. They have to meet the same experience requirements. They have to pay the same fees. We do not waive that. And you'll see in California, it's again limited to just 3 states at this time, and it's also limited by the certain classifications.
Any other comments or questions? Okay. Seeing none, thank you. And before we go into our next item, which is also a discussion, I'm going to call for a 10-minute break. So I'll see you back here at 29:40. Thank you. Thank you. I'll call the meeting back to order. And before we get started to our next agenda item, which is a discussion regarding CSLB and NSBC enforcement activities, I just want to put on record that Jacob Lopez is present at our meeting today for the Contractor State License Board. And I also would like to recognize Mr. Matthew Miller. He is a senior field representative for labor compliance. And when we get to the discussion on the California side, I will invite him to come up and say a few words. Thank you. With that, I am going to turn this portion of the meeting over to Chair Martin.
Thank you, Chair Love. Next will be a discussion by both boards on enforcement activities, and representing California's board will be Jim Ruane, and representing Nevada's will be Terry White, and I'll turn the time over to them. And I'll let you guys decide who wants to go first.
Good morning, Chair Love, Chairman Martin, Registrar Vogt, and Executive Officer Green. I'm Terry White. I'm the Director of Investigations for the Nevada State Contractors Board, and I would like to share some of our enforcement activities that we routinely go through. First, I'd like to start off letting you know about what we've done in the past year. In the past year, with respect to our compliance division, that is our division that monitors licensed contractors. And I want to tell you a little bit about some of the discipline that's been imposed on these licensed contractors. We've had 206 citations issued this year alone. And those are administrative citations, and they are simply fines, and they are not formal disciplinary hearings. Those are simply our citations. We had disciplinary hearings on 372 cases this year against 107 licensed contractors. That is a relatively big burden. It's been a heavy year for the board. We often have 2 or 3 disciplinary hearings a month. Sometimes we will have to have a specialty hearing with one licensee due to the numerous complaints that they have against them. And you'll see the numbers on that too. With respect to our summary suspensions, I don't know if California has a similar rule regarding summary suspensions, but in Nevada, if we see a problem with a contractor, generally what triggers our attention is 5 or more open complaints. And when we see 5 or more open complaints, we want to take action immediately to reach out to that contractor and find out what's going on. And when we do that, we typically will call them in for an administrative meeting, and we'll talk to them and just simply ask them what is going on with their business. We've seen a few complaints coming in. This is in a short period of time. It's not 5 complaints over a year. It's talking about 5 complaints in just a month maybe. And we'll ask them what's going on. And 90% of the time, they've had something going on with their business. They've had either a customer service change, some other type of problem, and we'll ask them what they're doing to remedy that situation. At that administrative meeting, often they'll tell us they're working things out. What we'll do is we'll follow up with them, and we'll have them give us status checks every week on all their open investigations. So they will have to report to us after that point every single week as to the status of their investigations and what they're doing to close these items. If the number keeps going up, that's when we summarily suspend them. And we can do that the executive officer can do that in Nevada, and we will suspend them, and then we will set them for a hearing where the administrative law judge in our office will sit in front, or that contractor will sit in front of the administrative law judge and explain why the summary suspension should not be, or should be lifted, or whether or not it'll be affirmed. That is one of our most proactive techniques we can do with some of the contractors that we're seeing. And generally, when we see 5 or more open complaints come in to us within a short period of time, it accelerates rapidly. I'm right off the top of my head, I know of a company in Nevada. We had probably 10 open complaints. We called him in for an admin. He told us how great his company was, what they were, they were working on everything. They had embezzlement problems, all of these excuses. And 30 days later, we had 50 complaints. And they stopped working, they had closed their doors, and they were still accepting deposits, and they were no longer doing business. So basically, they were just taking the money at that point. But that's one of the enforcement techniques we use, is we try to get in front of them. We try to get in front of the problem contractors to do what we can. Now, with respect to our criminal division, we also have a criminal division where they're mostly retired police officers. And this is all in-house for the Nevada State Contractors Board. We had 672 criminal investigations regarding unlicensed contractors. Whether that's working while unlicensed or whether it's advertising. It could simply be that they're advertising, but if they're advertising, we know they're working also. So we're not blind to that. Of those 672, 67 of them were referred to the DA's office, and some of those might be multiple cases referred to the DA's office against one licensee or one unlicensed contractor. Okay, so it's not necessarily 67 unlicensed people going before the district attorney's office. We also work closely with the AG's office, and in this past year we've had 13 cases referred to the AG's office, those again might not be 13 different licensees. They could be, or unlicensed contractors. They could be, 2 or 3 with multiple cases, multiple investigations. Our criminal division issued 235 administrative citations this year. We issued 127 violation letters. The violation letters are simply more or less a warning that we're aware of your presence doing unlicensed work. We may not have had the evidence today, but we're watching you and we're trying to get in front of you. That's what we want to do. We also do, every week, we'll do random site visits to construction projects. We'll just introduce ourselves to the contractors and let them know that we're out there and that we're here to, help the good contractors that are out there. And part of our job, helping the welfare of the consumer, we have to remember we're also helping the welfare of good contractors that are out there too, by trying to get rid of the bad ones and trying to hold the bad ones accountable for what they're doing. And as you may not know, our recovery fund in Nevada is funded by the good contractors. It's not funded by state money. It's not funded by the taxpayers. It's funded only by the good contractors in the state of Nevada. So we want to protect those good contractors. We want to bring other good contractors under our umbrella and get them licensed, because that overall protects our consumers in Nevada. So that's important to us. And I think Ms. Green has made that abundantly clear to everybody that works for the Nevada State Contractors Board, is that she likes that protection. She lets me know it all the time, and I appreciate that. But we do the proactive site visits every week. We also conduct stings. We recently did a sting with the California board up at Lake Tahoe. We received multiple, well, the California board actually received, on one day they received 4 unlicensed contractors bidding above the handyman limit, and they're looking into further investigations on those contractors. 1 was a no-show. On the second day, there were 3 contractors that were supposed to show. 2 of them did show. They submitted bids, again, above the handyman limit, and 1 was a no-show. So they're doing similar proactive enforcement as we are. We try to do as many of these as we can. We actually have a house that in Las Vegas has been more or less donated to us, and we'll call contractors up and ask them to come on down and give us a bid for, remodeling the bathroom, redoing the tile roof, whatever. And they'll show up, and then we'll introduce ourselves. Those are kind of exciting points that we do. But the Tahoe event was great. We enjoy working with the California board on doing those type of stings. We hope to do more in the future. And I'm happy to answer any questions you guys may have.
Thank you, Terry. Any questions for Terry? Mr. Wayne?
Thank you, Chair Love and Chairman Martin. I'm Jim Ruane, the Chair of the CSLB's Enforcement Committee. I'd like to start off this discussion with a brief overview of how the CSLB's Enforcement Division is structured. Intake mediation centers, Sacramento and Norwalk. They focus on settlement and prepare unlicensed complaints for field investigations. Investigative centers, we have 10. Focuses on addressing violations of law, possible dispositions, could be advisory notice, letter of admonishment, arbitration, citation, accusation, criminal referral. Quality Assurance Unit, application experience verifications, public works projects, referrals from labor organizations and other stakeholder groups. Civil wage and penalty assessments issued by the Department of Industrial Relations. Electrical certification violations, subsurface excavation, dig alert violations, politically sensitive media coverage. I have a lot of bullet points, and I'll get through them as fast as I can. Special Investigative Unit, SIU, sworn peace officers focus on criminal investigations, complex financial fraud, and search warrants for bank records. Statewide investigative fraud teams, SWIFT. I was able to attend a couple of these, and they're very effective. 3 units in North, Central, and South of California. Response to leads, conducts sweeps. Undercover sting operations and labor enforcement task force works with Cal OSHA, EDD, and DLSE. Joint Enforcement Strike Force, Department of Insurance, EDD, DLSE, FTB, Cal OSHA, all different kinds of organizations. Disaster response, fires, earthquakes, and floods. Post-warning signs, staff local assistance centers, disaster recovery centers, and also we have a case management division which coordinates closely with accusations and various state agencies, including district attorneys. And next, I would like to provide a brief update on a recent joint enforcement operation conducted by CSLB and NSCB, which was briefly mentioned. Undercover stick operation was in South Lake Tahoe, May 29th and 30th, 2024. We had 8 appointments. DA referrals were 6, and the highest bid was $26,000 for a bathroom remodel. At this time, this includes the discussion regarding CSLB and NSCB operational and structural comparison. I will turn it back over to Chair Love.
Before I ask Mr. Miller to come up, I wanted to ask Mr. Grove, does he have any comments or anything to say?
Yes, thank you. I would just like to reiterate the appreciation we have with the Nevada Contractors Board's investigators who assisted us on that recent operation. We've done this several times each year. Usually what we do is we try to have a sting set up in California and one in Nevada, and then we send our investigators over to the opposite side to observe, and hopefully we'll be able to do that in the future. I guess there were some new staff, so they weren't able to set theirs up this year. But, the challenge with our sting operations, which is it's our bread and butter as far as getting the message out there, not to contract illegally, because we do a press conference after each one, a press release, and that gets a lot of attention out there. When these guys show up at the sting operations, they know about them already, and oftentimes they'll even say, "Oh, I thought this might be a sting operation," and they'll come to the house and they'll drive around a couple times because they're suspicious, but then they'll still come in and offer the bid. And prior to COVID, we were doing a lot more stings. We were doing around 90 sting days per year, and unfortunately, that has dropped off significantly. People are less likely to offer up their homes for us to use. So that's the big challenge that we have. We're always looking for sting properties, and as soon as we find one, we jump on it. So, and I'd be happy to answer any questions.
Yeah, I have a question. So curious, I know that the ultimate purpose is just trying to get the message out, but do we know if there's any data that shows the impact where it's really that message is driving clear and folks are wanting to get a license, and how do we measure the impact of, is it less people coming to the stings, or is it, and it's probably not a clear question, but I'm just curious of how we measure the impact of the stings and the effectiveness.
Well, unfortunately, I don't have any data like that. The reality of it is, if we had a lot more investigators and a lot more sting properties, we could do a lot more stings and catch a lot more people. It's just a resource limitation. But our investigators, our SWIFT investigators, have a package. They carry application packages in the trunk of their car that during the sting operation, after the arrest is made, they hand a application package to the individual and encourage them to get licensed. They also carry them around in the trunk of their car when they're doing their sweeps and responding to leads. And so, yeah.
Thank you, Steve. Before I invite up Mr. Miller, I just wanted to share with all of you that I had an opportunity to witness one of the stings in Bakersfield, and it was very interesting. I would like to do another one in perhaps another part of the state, but I just want to share a funny story behind that. What I learned in being there was that they're set up by appointments, sometimes 45 minutes to an hour in between, and there were several appointments that day. And right after one of the appointments, immediately after one of the appointments, it wasn't supposed to be another appointment for like an hour or so. So I stepped outside to make a phone call in front of the property. And while I was there, this house was on a corner house. There was a gentleman who pulled up to the sidewalk, to the curb, and I just got a funny feeling that he was there to be a part of the sting operation, and he just sat there for a moment, and then he moved off and he pulled over into the driveway next door and turned around and came back, and I immediately thought, wow, how do we justify me being there in front of the house and to be part of this sting? So I rushed back in to tell the folks that they were there. So he came early. He came extremely early, and he was part of the sting. So what they did was they told him that I was a realtor. that was there to justify the means of me being there, because I didn't want to spoil what we were doing. But it was very interesting, the procedures that they go through, the sheriffs being there, then putting them in handcuffs. There's someone there who interprets in Spanish if you're a Spanish person that's coming in to give the overall procedure. But it was quite interesting. It wasn't exactly what I expected it to be. I thought it was going to be more detail, more interaction, but actually you sit there because everything is being recorded. Everybody has on microphones and different things to record what's going on to make sure it's done properly and in order. But I have to say the sting operation is a very useful tool and is something that we should always continue to do. And hopefully we do get licensed contractors from that experience because we try to provide in a lot of different ways, including sometimes reducing in fees and helping with the application and different things like that. So it is a very useful tool. So thank you for indulging me with my sting story. So Mr. Martin, please come and, Mr. Miller, excuse me. I've changed your name.
Yeah.
Hi, thank you. I'm Matthew Miller. I'm the Senior Field Rep for Labor Compliance with the NorCal Carpenters Union, and I just wanted to thank Registrar Vogt and Chief of Enforcement Steve Grove for their willingness to partner with us and work with us, both at the NorCal Carpenters and our Labor Management Cooperation Committee, the Workforce Defense League, and specifically Chief Grove setting up a meeting with most of our field staff and his quality assurance team to have a really frank discussion about kind of what they can and can't do to limit, our expectations or put them in check, but also really answer our questions and help us work, do a better job of presenting evidence to them so they can enforce the law. So I want to thank you both and everyone on the board.
Thank you. Are there any questions or comments from board for either of the presenters? Anyone from the public have any questions or comments? Okay, thank you.
Thank you, Chair Love. This portion of our meeting, the discussion is going to be led by Ms. Green and Mr. Fote, so I will defer to them.
Thank you. I believe I'm going first, right, Dave? So for today's discussion, we're going to be highlighting 3 proposed legislative proposals we've submitted to our legislature. And for those of you in California who don't understand how the Nevada legislature works, our legislators only meet every 2 years, and they only meet from February until June. So it's a very short period of time, and a lot gets done during that time. So we have time to prepare in the interim. It's also a nice break when I listened to your legislative discussion yesterday. That just keeps you busy year-round talking about all of that. So we're a little bit more fortunate that our legislature just meets every 2 years. But the board we have the ability, like you do, to submit our own bills. We have 3 proposals that we've submitted to the governor's office and to the legislature. And so I'll highlight those 3 topics. And as previously mentioned, solar construction in the residential world has proven to be an area that requires greater oversight and consumer protection in recent years. One way that we plan to address this is one piece of proposed legislation is requiring payment performance bonds on all residential solar contractors. So the material in your books has this new language that we're proposing to be added to Chapter 624 of Nevada Revised Statutes, which defines the new criteria when a payment performance bond is required. These include new licensees or individuals who renew their license after January 1st, 2025, licensees who have violated one or more provisions of NRS 624, licensees who have 5 valid complaints filed within a 15-day period, and licensees who contract after July 1st, 2025, if that contract is found to be void and unenforceable under the standards of the board. Both the payment and performance bond requirements must equal 100% of the amount of the contract. The performance bond is solely for the protection of the homeowner of the property to be improved, while the payment bond is solely for the protection of the person supplying labor and materials to the contractor or any subcontractors carrying out the provisions of the contract. Although this is not alone a one-fix-all solution, we believe it will add financial protections for the homeowners, and then also added financial responsibility on the licensees undertaking these projects, and especially those who are identified as non-compliant with the law. And again, this is all for consumer protection. Another bill that we're proposing seeks to enhance protections for people that are cooperating in board investigations while creating measures to hold licensees who disrupt this process accountable. The integrity of our investigations and the ability for a board to gather evidence to uphold the laws and regulations of the industry is only as good as the information provided at times. So acts of intimidation, harassment, and threats are not uncommon when people's livelihoods and work ethics are being questioned, and we've noticed instances when our investigations have been negatively impacted because of these actions. This new language provides clear and direct authority for a board to address these instances when they occur and hopefully deter future impediments to our investigative process. Lastly, our third piece of proposed legislation is looking at opportunities to hold unlicensed contractors even more accountable for their unlawful actions. We have had a series of contractors, and I'm not saying from which state, come into our northern Nevada location, and they're bidding on huge projects in the industrial centers that are going on there without a license. And so we will issue an administrative citation or fine, then they turn around and get licensed and continue to do the job. So what this new piece of legislation will do is provide the board an opportunity to prohibit them from getting a license for up to 1 year when they have submitted a project, because and it's not going to be something we do on every single case, but we're going to look at the totality of the circumstance and how they bid it and what those provisions were. So our goal, of course, is to ensure that everyone is licensed, but we also know many unlicensed contractors deliberately seek out projects that violate the law and place consumers and owners in financial risk in the process. So each of these changes or proposed changes will be subject to modification. We're early in the process. We like to get our bills in early, so we're first out of the chute. We have them pre-filed. We're currently meeting with industry groups and legislators to discuss our proposals so that we get the support we need before session starts in February. So that concludes my presentation on these items. And are we going to ask questions at the end, or?
I think well, are there any questions for Ms. Green currently from board members? If not, thank you, Ms. Green.
Thank you.
And we'll turn the time to Chair Love to lead the California discussion.
Thank you. In your packet, please turn to page 179. And in the absence of Michael Mark, who's the chair of that committee, Registrar David Folk will be doing the presentation along with some slides.
Okay, thank you, Chair Love. Yes, on page 179, what we have is a summary of our sunset bill. Like Nevada, California has the sunset provision, and the CSLB will need an extension to remain a board, and we need that by January 1st of 2025. So we do work with industry. We work with the legislature very closely in drafting or crafting that sunset bill. The idea is to find opportunities for the state legislature to help our board with our consumer protection mandate. Initially there was 8 new issues, but I'm not sure that they're all in the sunset bill today, but I am confident that the 3 I want to discuss are. And the first would be reimbursement for industry expert costs. We do have an industry expert program, and for a lot of our workmanship complaints, we pay another contractor, we pay an industry expert to go out and provide a report, do an inspection and provide a report for work that is allegedly incomplete or defective. That helps us to settle complaints. And I talked earlier about how we were able to recover $31 million for consumers. That industry expert program plays a real significant part in that achievement. The problem, though, today is that we do have contractors that will rely on it. We've had situations where contractors have encouraged their customer to file a complaint. That's not sustainable. We want consumers to hire a licensed contractor and not need to file a complaint to be satisfied with the process. So what we're proposing is that if we have to send an expert out to tell you how to correct and complete your project, you need to reimburse that cost up to $1,000. Now, we don't want to continue to do that for any contractor, but if we do have to do it and we issue a letter of admonishment or we take an administrative action such as issuing a citation, we want to be able to recover that cost. The second is we issue citations and we establish the proposed civil penalty, but it can be and is often appealed by the contractor who has the opportunity to make a defense in front of an administrative law judge. And we find that administrative law judges can be sympathetic to the contractor. It's not a strong deterrent to have your civil penalty reduced down to a couple $100s. So we need minimum fines. We have some fines now that are up to $30,000, but what is the minimum so that we know going in that if you've violated workers' comp as an example, the lowest fine you're going to pay would be $1,000 as an example. I'm not sure how this will come out, but we need to have the threshold for minimum fines. And the other one that we're real excited about is the ability to license Indian tribes, tribally owned entities in California. Currently, we can't do that because we can only license sole owners, partnerships, corporations, limited liability companies. We need the authority to be able to issue that Indian tribe. Members of the tribe could obtain a license, but we can't license the tribe themselves. And this would apply when a tribe wants to go outside of their designated land and do work. So they want to go out into other communities and do work. They're going to need a contractor's license. We'd like to be able to issue that license. And just the last bill I wanted to touch on is AB 2993 Grayson. And why we're excited about this is because we find that in California we have lenders that are paying the contractor directly. You go back a few years ago, you didn't see that. A consumer would go to the bank, they'd get a home improvement loan, they would control those funds, they would pay them out as appropriate. But it's a problem when the lender has a working relationship with a contractor and is paying those contractors directly and not confirming the work was done. We really saw that with our solar recovery fund. We had a contractor, as I mentioned earlier, that hit the fund for almost $1 million. That happened because of the loan. So you have a consumer paying back a loan for a product or a work of improvement they didn't receive. So what this would do is it would require that the homeowner, it's for home improvement, the homeowner would have to confirm that the work was done. Now, Steve Pinelli is one of our board members. He's not here today. He was very concerned that it's putting too much pressure or responsibility on the homeowner. So we want to keep that provision in. But we want to have a requirement that the lender have to contact the building department to confirm that permit was final, that the building department confirmed that project is complete. And if it's complete, then it should be operational. Now, that's not always the case in solar because often you have to get the permission to operate from the utility. But nevertheless, this would be a real step in the right direction. And I'm also going to mention the California Storage and Solar Association, who's with us today, CALSA, because I think they could play a role in helping to determine when progress payments should be made. I know their chair has been somewhat helpful in that regard, because if a payment is going to be made to the contractor, it's a progress payment, it needs to be equal to the amount of work that was performed. So we have made that requested amendment to the legislator. Assembly Member Grayson is carrying this bill. We believe it's going to be included in the bill. And so yesterday, the California Board took a support as amended on that bill. But we think that's really exciting because in California, a contractor is not supposed to request or receive money in advance of work performed from improvement. The same thing should apply to the construction lender. They shouldn't be able to make those payments to that lender. Lenders are regulated by different departments, Department of Financial Protection and Innovation in California. This would give them authority to hold those lenders accountable. So that would be the California legislative update. If there's any questions?
Any questions from the board members? Any questions from the public?
This is Josh Buzzell-Charco with the California Solar and Storage Association. Thank you for the acknowledgement, Registrar Foat. Just wanted to state that we also are supportive of the recommendation that you stated where lenders would have to confirm that there's been sign-off from a building inspector from the lender, and the lenders are supportive of that as well. So just want to say that.
Thank you. Any other comments from the public? And to our next item, which is a discussion concerning solar contractors. And I'm going to ask Board Member Jim Ruing to take the lead in discussing the following topics, along with Terry Wilk and Randy Wyke.
Terry White. Randy's not on this one, just
Okay, along with Terry.
All right, thank you, Chair Love. I'd like to start up the discussion on solar contractors by providing some brief statistics on solar complaints. When comparing fiscal year 18-19 to fiscal year 22-23, CSLB has seen a 176% increase in solar complaints. CSLB has more than 900 open solar complaints, which is more than 20% of all CSLB open complaints. The excessive number of solar complaints has created high caseloads for enforcement staff. For the reporting period of July 1st, 2023 to April 30th, 2024, 16,173 total complaints were received and 2,014 solar complaints. $31 million awarded in restitution for all complaint types, $3,985,000 awarded in restitution related to solar projects. Enforcement strategies, we have a multiple offender unit to provide effective consumer protection and address this unsustainable increase in consumer filed solar complaints. A multiple offender unit was established in December 2023. The goal of this new unit is to focus on solar contractors with the most open complaints, assign all of the complaints against a contractor to a single investigator, and take swift, aggressive action to persuade the contractor to resolve pending complaints and change their business models to resolve consumer concerns before their customer finds need to file a CSLB complaint. These contractors will be subject to legal action if they do not resolve their complaints in a timely manner or continue to receive complaints, and a violation of contractor state license law is supported. This new aggressive approach sends a message to solar contractors receiving multiple complaints that they need to take necessary steps to prevent their contracts from resulting in a complaint to the CSLB. We have a slide on the screen there. This slide provides the MOU structure. Currently, 5 staff are assigned to the unit part-time. A former retired CSLB peace officer and a retired special investigator should join the unit this month as retired annuitants. Continuing on, we have a CSLB Multiple Solar Offender Task Force. Interagency Solar Consumer Protection Task Force is another successful enforcement strategy. Is collaborating with other agencies to share information, ideas, and resources for addressing solar construction complaints. For the past several years, CSLB has participated in regular meetings with the Interagency Solar Consumer Task Force. On April 26, 2024, CSLB and NSCB staff, including Registrar Margie Green, attended the most recent Interagency Solar Consumer Protection Task Force meeting. Other participants included the California Public Utilities Commission, the Nevada Bureau of Consumer Protection, and the California Department of Financial Protection and Innovation. We'll now discuss the Interagency Solar Consumer Protection Task Force. The slide above there will include agenda items from April 26, 2024 Task Force agenda. I want to thank Margie Green and representatives from the Nevada Bureau or Consumer Protection Agency for participating in this meeting and sharing their new strategies for addressing solar fraud. CSLB staff discussed the multiple offender unit and how partnering states and other government agencies can assist in sharing information to hold violating contractors accountable. In California, the Department of Financial Protection and Innovation, or DFPI, has jurisdiction over lenders such as the Property Assessed Clean Energy PACE program and other so-called green lenders. DFPI is a vital partner in addressing lenders that pay contractors directly before work is completed. There's a screen showing that. I now open it up for board member discussion, and this concludes the discussion on my part. I'll turn it over now to Terry.
Thank you, Chair Love, Chairman Martin, Registrar Vogt, and Executive Officer Green, and members of the board and the public. I have to agree with Jim's statistics. We're seeing very similar statistics in Nevada. I've prepared a little bit of a PowerPoint here. In 2023, we had well, for the past few years, solar installations have been trending up about 500,000 a year. Okay, we're now seeing a substantial increase in that. And if we can, there's approximately 85 million eligible homes. And right now, there are only approximately 5,000 homes that have solar. That means there's room for a very large increase in solar installation projects. Currently, the Nevada State Contractors Board, at this time last year, we had approximately 161 solar complaints. Right now, we have 289 for this year. That's a 56% increase. That's a significant increase. And that's almost trending towards 30% of all of our cases in the state of Nevada. And that's a very high percentage for us. But if we can look at the next slide, here's one of the problems that we're having in Nevada. This is how an unlicensed contractor actually does his marketing and advertising. I was pulling up to the intersection at Sunset and the 215, and I'm the first in line at the stoplight there to turn left, and the board's office is just right on the other side of the freeway. And I look out, towards the board office, and I get hit with this sign. And I thought, I should probably take a picture of that and send that over to our criminal division. And I did, and they're investigating this gentleman, and he is unlicensed, but that's what we're seeing. And these are posted almost on every intersection anymore. Okay, so it's not one and done. This is a problem for us, and we're seeing certain types of cases. Let's talk about the types of cases that we're seeing. We're seeing workmanship. The workmanship cases are generally due to an inexperienced QI. That's a qualified individual. He has a C2 license, which is an electrical license in Nevada. They can install solar with that license, but he's never done it before. He's always done lighting or other type of electrical work. He doesn't know anything about inverters and other components of the solar, but he sees the lucrative industry and he wants to be part of that. And that's exactly one of our problems. The other problem is now how does he train the installers if he doesn't know how to do them himself? That's the other big problem. It's much easier to train a salesman for the weekend on how to go out and sell solar all weekend long. You take them through a 3-day class over the weekend, you get them out there selling solar for you, but then now you don't have the installers to actually install those solar systems once they enter into the contracts with the homeowners. That's a big problem. And then the last part of it on the workmanship is You simply just have the inexperienced installers, or they make mistakes during the installation. Even some of the good contractors will make mistakes during the installation, but they generally will come back and take care of their issues. But there's often just your typical workmanship issues. But the big ones we're seeing is the lack of experience. And labor in that industry is difficult to find. They're in great demand. There's a lot of companies out there wanting to do solar. It's very lucrative. So we're seeing that. The next kind of cases that we're seeing is the abandonment. What I'm experiencing with the abandonment is a lot of times it's material or products to install the systems. They're not getting their supply lines down. And they're entering into these contracts where they're telling the homeowners that the expected completion date will be 3 months out. And yet we're a year out and they still haven't installed the inverters. And they still haven't got the PTO, the petition or permission to operate, or the building permit as was discussed. That's a big problem between the building permit and the energy or in the power company, whether it's NV Energy or whether it's the building department. We need to see better cooperation between the two in addition with the lender. And I'll bring that up in just a minute. But the lack of components, the lack of the supply chain, and the lack of the sophistication of the solar contractors in making sure that they're putting deadlines in their contract which are realistic based upon the supply chain. That's what they need to be doing, and we're not seeing it because they all want to sign you up as quickly as possible. The next thing we're seeing is the lack of incentive by the solar companies. And that lack of incentive is present in most cases where there's a lender involved. And that's because the lender pays them up in full as soon as they get that contract signed by the homeowner. Now that evades our schedule of payments requirement in our laws, but the fact of the matter is it does not create incentive for that contractor to come back and complete that project. He wants to go sign the next case, the next project, to get that full payment from the lender again. And so we're having a big problem with that, and it's just basically a lack of incentive to go back and get the PTO, go back and get the building department approval, and do the other things that they need to do to get the system going, whether it's install inverters or whatever. So that's a big problem for us, just a lack of incentive and the evasion of our statutes in Nevada by using the lenders. I'm looking at that carefully on how to rectify that. I don't have an answer yet, but believe me, I'm looking at it. The misuse of license is another thing that we're seeing. And the misuse of license comes because the solar companies are damaging the roofs. Then they're repairing the roofs, and they don't have a roofing license. That, again, is a big problem. They're also, in some of these solar contracts, they're providing windows, okay? They're not a window installer either. They're just a solar installation. They're just a C2 license in Nevada. So we're seeing a lot of those crossovers into other areas because they're selling them this entire green package. And this entire green package, they're not licensed to provide. And in Nevada, I'm not sure exactly how it is in California, if you have a electrical license, you can't hire a roofer to repair the damage that you did to this house. Unless it's incidental damage, if they have to have a re-roof, you can't include that in your contract. You have to have that roofer contract with the homeowner specifically. That way the homeowner has the protections from that roofer. So we see a lot of that going on. And so we see a lot of the misuse of the license. And the fraudulent and deceitful acts. There's multiple issues that we're seeing here. We're seeing, the salesperson's going out there telling them that they're not going to have any power bills, trying to convince the homeowner to enter into this loan with the lender. And what we recently found, we issued subpoenas to GoodLeap, and other lenders based upon some of our solar investigations. And what we found is that the solar system the customer is purchasing is a $50,000 loan. $15,000 of that loan is being paid to the lender right out. That's not even going to the solar installer. They're getting paid $15,000 for funding that loan. And so we have high-risk loans being generated because these lenders are being paid up front. So the actual installer is only getting $35,000. And there's a specific AG's office in Minnesota has now brought action against Good Leap and other lenders regarding that specific behavior. And so that's a case that's pending in Minnesota. And I've already went over, the Fraudulent and Deceitful Act is telling them, we're going to have your solar system up and installed in a short period of time when they know their supply chain can't handle that. That we consider that a misrepresentation to induce them into the contract. The no permit, a lot of them are beginning the installation of the solar system without a permit. And then when they get caught, of course, they're saying, oh, I'll go get the permit. And, we hold them to that. But we still issue a citation for starting work without that permit. And then outside of scope, again, that's basically doing roof and windows and all these solar blankets and other fancy things that they're doing with the green energy. We're trying to develop consumer awareness about these facts. And how we do that is we monthly meet with either HOAs or we meet with senior communities, and we'll send our investigators out and we'll just talk to the senior communities about solar and about other workmanship, not just solar. We have a lot of remodeling problems in Nevada. We have a lot of patio cover problems in Nevada, or contractors that do that type of work. We have some problems with that too. But we try to reach out to the community. We try to get out there every month. We speak to property management companies, not just the company, but the entire property management with LVR, which is Las Vegas Realty. They hold property management meetings, and I recently spoke at one of those, talking to the property managers about hiring unlicensed contractors and handyman and all the other stuff they're doing. We want increased accountability. We do, as I discussed, we have the administrative meetings with them. We get the weekly reports. And then ultimately, if necessary, we either issue a fine, we issue a suspension, or we may revoke their license. We're trying to partner with everybody we can. One of the things that we have in our favor under Nevada law is violating some of the solar provisions in solar contracts will void the contract. We don't enforce that voiding of the contract, but the courts can. And we partner with the legal aid of Southern Nevada and in Northern Nevada, and we help them advise homeowners as to whether or not, if they want to get out of their solar contract, to talk to the legal aid department in both jurisdictions. That's the best assistance we can give them on that, but we make sure they're aware of their rights with respect to that. We're trying to work with NV Energy. We actually have a solar task force now in Nevada, and we have the opportunity to have a representative of NV Energy on that task force, and we're hoping that will occur. It hasn't happened yet, but we're keeping our hopes up, and they've indicated an interest. So I think that would help us, especially with respect to the permits and the PTOs to permission to operate, because we're seeing a lot of those systems that are installed and then they're not operational, and they haven't been operational for some time.